Hello, and welcome to Stowe Talks, a podcast designed to support people going through a relationship breakdown and all the challenges this brings. I'm Matthew Taylor.
And I'm Liza Gatchell, family lawyers at Stowe Family Law. And today we're joined by Sushma Kotecha from Holistic Family Mediation to look at how mediation can help couples work together to have a more dignified and amicable separation. So firstly, thank you so much, Sushma, for joining us today for the podcast.
My absolute pleasure.
And it'd be really helpful if perhaps you could just give us a bit of background about yourself and how you found yourself in the mediation world.
Oh gosh, where to start? So my background, I have been in the industry for about 3 decades, practiced as a family lawyer for 27 years. My last position was actually with Stowe, interestingly. We've just had a chat about that off air. And mediation, that was always actually my radar. So since I qualified as a lawyer back in 1994, I've always sort of wanted to help couples separate in a kind of compassionate way. So a big advocate of dispute resolution. However, at the time when I first started, I guess it wasn't a huge topic or a huge area where partners within the organisation wanted to invest in, because of course you'd have to train, take a number of days out of the office, and as much as I try to put myself forward to train as a mediator, I was being sort of kicked back. And then I got to a stage where I actually decided to self-fund. So I trained as a mediator back in 2010. There was something within me that was saying, well, if the partners or the bosses were not going to pay, it's something that I really want to do. So I'm going to have to self-fund. And so I did that back in 2010 and qualified. And shortly after qualifying, I did give up my legal hat for about 6 months and joined a niche mediation service in Leicester, Sue West Family Mediation, which is brilliant because that gave me a huge exposure to dealing with mediation work, and I could then build my portfolio. So to become an accredited mediator, you have to go through hoops and loops and God knows what else, walk on coal, put this portfolio together to evidence that you are able to, deal with all issues in terms of separation. So I've got finance and children. And once I got that gold badge of honour and got my accreditation, that led on to further opportunities. Doors had opened. I joined Shoesmiths, and then, as I said, finally at Stowe. But it was at Stowe during lockdown that I decided, well, I'm only doing, I'd probably say, a handful of mediation cases. The majority were litigation, being a lawyer. But that didn't kind of sit well with me. So over lockdown, I had the opportunity to think about, what serves me and what do I really want to do and put out there. And I think, like I said before we got on air, that I felt it was like my calling to give up my legal hat and just follow my heart and my passion, which is to help couples deal with their issues arising out of separation in a compassionate way. And just to add a personal sort of note and story, I've been through my own separation and divorce. So I guess it was at that point when I realised, if I'm literally on the floor and on my knees with my own separation divorce, with all this experience as a lawyer, what is it like for our clients? And so that was sort of another catalyst to make me, follow my heart, my calling, and to put this service out there.
Great. Well, I mean, first things to say is it's lovely to have another former Stowe body on the podcast and join. It'd be nice for the listeners to hear from someone from Stowe other than me and Lisa for a change. So I think let's just start with the absolute basics, because I think if you can just explain, Sushma, what is mediation? Because it's something we talk a lot about with clients. And I think that, we explain it, but often clients hear about it from us at a stage where they're finding out about so many different processes, and it can all be a bit complicated and a bit confusing. So, how do you explain mediation to someone going through a separation?
Yeah. So, yeah, you're absolutely right. We need to go back to basics, and it is overwhelming. And I guess the key thing to bear in mind is when clients come into our doors, and I know what it's like from a lawyer point of view as well as a mediator point of view, emotions are all over the place. But simply put, mediation is a dispute resolution option, so an out of court resolution option, which allows the parties to reach their own informed decisions with the help of a third party neutral mediator like myself. And the idea behind mediation is to allow the parties to remain in control and not give the decision making over to a district judge or a bench of magistrates that don't know the family. And I guess I'd say that the mediator's role, and for the clients and those that are listening, to be clear, it's also to help them not only with the legal aspects, but also the softer topics, the communication, boundary setting, ground rules, which usually lawyers or the courts are not really too concerned about.
So, how does the process work then? If someone's thinking, "Well, that sounds good. That sounds exactly the sort of thing that I would want," and I think pretty much everyone would think that to start with,
Yeah.
give us a bit of guide to the process of how it works in practice.
How it works in practice. So in terms of how to engage a mediator, typically the starting point is to make a referral. So mine's is an online service. And I think most firms these days will have an online referral form. So it's making that referral, whether the lawyer would engage the mediator or the client can make a self-referral. Once that referral is made, the mediator would then get in touch with both the parties to invite them to have initial separate assessment meetings. So the term MIAM is sort of bandied about quite often, and people look at what is a MIAM. So MIAM is a mediation information and assessment meeting. And so within those separate assessment meetings, it's the mediator's role to explain to them the core principles of mediation and how it does work in practice. And we'll go into that in a moment. And also to gather information about their individual circumstances. So we ask for a background information form to be completed, so we get a bit of, what issues do they want to sort out. And one of the fundamental elements of a MIAM is the safeguarding and screening to make sure that it's safe and suitable. So not every case is going to be safe and suitable for mediation, right? So in terms of how it then would work in practice is, let's fast track to say we've had the two separate assessment meetings that is assessed as safe and suitable, no major red flags. Then it's a case of setting up the joint session and having a joint mediation meeting with both the parties. And ahead of that joint session, they will also get information in terms of, the law that may be applicable to Children Act application or finances. So whatever they've decided to purchase on my particular site, so it'd be in all issues or children only or finances only, they're going to get a package of documents to help them, I guess, understand the law firstly, because sometimes they don't have lawyers. But in terms of then actually getting into the session, the role of the mediator is to help them, build an agenda. What are the core, issues that they want to try and resolve, and then also helping them to sort of understand what are the common denominators. So for me, I always try and address the fact that when it's children, usually that is their main area, common denominators where they want to focus on, and they've got a lot of, I guess, agreement. So it's just trying to remind them that all is not lost. There is some degrees of agreement there. And then we're kind of going through the various issues and giving them, both of them some airtime, I guess, to express their views on each of the issues. And I'm there then to give guidance as they go along the various issues to sort of make sure that their expectations are managed in terms of what is feasible, what isn't, what will the court endorse. There are some proposals that are made which I know are never going to be considered, reasonable, so I can kind of give that guidance information, but always advocating that they have legal advice, to manage the rights and responsibilities, because mediation, in my view, tends to work better where the parties have that in place. And ultimately doing the evaluation of what proposals are put into place, can we actually then implement them? So it's a net effect. What does it mean to mum? What does it mean to dad? What does it mean for the children? So when we're looking at children, it's always been child-centered and child-focused. Even with the finances, I will always bring the parties back to how is this going to impact on your children's needs, because as we know, they're going to be considered, first and foremost, really. So that's how it would work in practice. How many sessions you have, it's a case of, how long's a piece of string. We can get into a session and we think it's going to be productive because it's all being future focused, right? So that's a key element here, is we're not going back into history. It's not therapy, it's not counselling. And so if it becomes toxic, or if I can't manage the emotions or the conflict, then of course we're looking at different ways of them, moving along the process. It's not litigations first. We'll look at other dispute resolution options, and that's really important. So court is always the last resort. So mediator is always trying to steer the clients away from court, unless, of course, there is no way out, and the only way forward is going to be, through the court process.
Okay, that's really helpful. At the beginning there, you were talking about the MIAM, and you were saying about doing an assessment of what's safe and if it's safe and suitable to move forward, and looking out for red flags. Could you just give us some examples of situations or circumstances that might create those red flags, whereby actually you might think mediation isn't suitable, and why perhaps it wouldn't be suitable in those circumstances?
Yeah, typically the red flags are where there is severe domestic abuse, so not a one-off incident occurring where one party feels incapable of sharing space, so whether it's physical or virtual space. So if they're not going to be able to speak for themselves, mediation isn't going to be a suitable way forward. The power imbalance might be such that I cannot, redress the balance. So the mediator is always there to try and redress the imbalance. But if it's plainly obvious that one's going to be shaken in their boots and they can't share space and they can't speak for themselves, there's got to be a different alternative route for them, and more than likely that's probably going to be the court route, lawyer led. And I often say to clients, how do you feel comfortable with your lawyer in front and you in the back, in which case it's lawyer led negotiation or in court proceedings or maybe arbitration. But if they're feeling comfortable with them at the front and the lawyers at the back, then this is a safe and suitable environment. The other red flags are, severe welfare issues regarding the children. So if there had to be an investigation regarding concerns about drug abuse, alcohol, or even any kind of, physical, emotional abuse to the children, then this is not a forum within which it's going to be, sorted out, because I don't have an investigative role. So I guess going back at a stage, the 4 core principles of mediation, is that it is a voluntary process. They come here by choice. So even if I assessed it safe and suitable, they don't have to mediate. So they always have a choice. It's a confidential process. So whatever we say within the mediation forum, they can't then use in litigation. So I always make that very clear. It's a safe space for us to think outside the box, to have tentative discussions about possible solutions, resolutions, right? And then I'm not making the decisions for them. So again, very important to assess their capacity to mediate. Ultimately, they've got to make those decisions with my guidance and tools and resources that I share with them, and of course, whatever legal advice they have. But I'm not going to call it for them. So that's very important that they've got the capacity. So if there is a capacity issue, severe mental health issues, then that's going to be a clear red flag. It's not going to go ahead. And then finally, the core principle, of course, I've already mentioned, is I come to the table as third party neutral. So I don't take the parties' sides. They've got to be able to speak for themselves, which I again make very clear in the assessment meetings. So those are the main things in terms of being clear on.
You mentioned something there which really rang true with me, and this is a phrase that I use quite a lot when I'm discussing mediation as an option for my clients, and it's power imbalance. That's obviously most apparent with domestic abuse, like you've said, but often you get the situation where it's sort of quite stereotypical, but you might have a high earning husband who has financial control and has always dealt with the finances, not necessarily through any ulterior motive. It's just the way the parties have run the relationship.
It's always been.
Yeah, it's always been that way, and the wife doesn't really know about the finances, and maybe has been her role in the has been to stay at home and look after the kids, and the husband is a high achieving businessman who goes out and negotiates deals day in day out. And that's something that I talk about with my female clients, about there being a power imbalance from a negotiation perspective. So how do you address that sort of imbalance in mediation?
Matt, that's so interesting, because I've just had a recent assessment where I've had assessment meeting with a husband about a month ago, and the wife's only just booked us in. She had a bereavement in between, so normally you'd have the assessment meetings within a couple of weeks of each other. But yeah, so she is completely in the dark when it comes to finances. And so, yeah, that is a kind of a red flag, but it's not a total red flag or a bar. But obviously what I'll explain to them, that we mirror what a court would do or what lawyer-led negotiation would be in terms of the full and frank disclosure. So that is obviously something that's going to take place regardless of whichever forum they're in. And then I will be saying that within the mediation, if she does wish to give mediation a go and she doesn't feel totally in the dark and she does feel capable of with my support, and in the background, I guess the key emphasis on this case was, you will need to take legal advice, because you don't want to feel that you're completely at loss, because I can't give you advice. I certainly give you guidance, and I'll be able to ask the questions that she may not feel capable of asking or even knowing about asking. So we're curious in mediation. So when we go through the disclosure process, I'm going to be able to highlight if there are gaps, and where they do then need to seek legal advice or get a joint expert in place. But they do need to feel capable and confident and competent, as I said, to front load the mediation. And I always kind of use this sort of example, because you're here, your lawyer's at the back. But if they're going to have a complete meltdown and this isn't going to work, and probably it's going to go over their head, then they probably want to look at other models of mediation, where you can have the new model where you've got lawyers engaged within the mediation model. or roundtable meetings or collaboratives, so they don't have to go into court. So then I'll start talking about the other options that may be available if they don't feel that even me as third party neutral, with the knowledge of the fact that he or she's not got that financial capacity or information, or are very blind to it, if they don't feel safe coming into it, even with me sort of saying I will be able to try and redress the balance, then they're going to have to go down a different route. So again, I'm not pulling the wool over their eyes. I'm being very transparent about what we can and cannot do.
Yeah, that's really interesting. And somebody that's perhaps attended the MIAM and now they're looking to move forward with a joint session, what tips would you give them on preparing for that? What should they be doing?
Oh, interesting. So I do send 13, tips for successful mediation out ahead, of the joint sessions. In fact, I send it out when they have their assessment meetings with me. And, some of the things are not necessarily, I mean, obviously the usual things are about making sure they go and do their homework and seek at least some legal advice before they come into the first session. But it's just about preparing themselves emotionally, psychologically, in terms of breath work, grounding, going for a walk. It's the frame of mind. For me, you've got to come into mediation where you've got a clear headspace to have sensible dialogue and not be led by your emotional brain. So I kind of coach them, if I can call it that, in their separate sessions, because I'll be able to sort of assess where they are along the bereavement curve. So divorce and separation, from my point of view, is a living bereavement. So you could be in shock, denial, anger, and if you're there, you're not going to be able to have a clear headspace. So it's again just giving them the tools and resources to say, look, if you do want to mediate, it's important that you are able to regulate your emotions and come in with a clear headspace, and even have your setting, because typically when back in the days where I would give mediation on a face-to-face basis, I'd make sure that the room was set up nicely. I'd offer them tea and coffee, and they've got drinks, tissues, whatever they need by them, paper and pen. So all that information is given to them in advance so that they can set their stall up so that they're comfortable. And also just reassuring, when we get into the mediation session, both of you might think that you can do this, and maybe there's going to be a wobbly moment, or emotions get the better of you. Well, let's just take time out. So all these hints and tips are given at the separate assessment meetings, and also when they do come to the joint meeting, it's again me just reminding them of these things that can be put into place if needed.
It's a really nice rounded view actually you give. And I mean, the name of the company is Holistic Family Mediation, and I understand that you're currently a student of the Holistic Coaching Mind Body Practitioner Diploma. So how would the mediation that they experience with you, how would that be different to if they went to just a straight mediator?
Yeah, and I guess that's my unique selling point. So the fact that I've called it holistic family mediation might actually turn some people away. So holistic is basically giving the message that this is going to take into account their, mind, body, spirit, and soul. So the impact of their divorce or separation, I would consider, as a trauma. I've been through my own separation, divorce, so I come from a place of knowing. And so my service, I guess, is different to the extent that I'm always also going to be focusing, them on how is this impacting on their mental health. Do I need to give them tools and resources to help them with that, on their physical, health, and the emotional health. So it's really much pro advocate of counselling, therapy, and coaching alongside this. And even if mediation doesn't work out, I would also, and I think many mediators will give the tools and resources in a bespoke way to say, okay, you're not going down the mediation route, but it's worth having these things in place so that when you're going to your lawyers are not to be used as an emotional crutch, because they'll be expensive and they're not qualified to do that. So, go to those that are qualified to help you. And then you're going to have that clear head. And you know what, sometimes, Lisa, the point is that they're not ready and they just need some time out, right? So again, take a breath, take a pause. You don't have to go at this just because you're on this railroad track and you're thinking, now I've sorted it, I've got to continue. Sometimes you do need to pause, and sometimes it's a rethink. So holistic is just sort of having, not only looking at the family as a whole and impact on mum and dad and the children, and I guess friends and extended family. That's one way of looking at holistic, but in my book it's also the mind, body, spirit, and soul element, so bringing that all into the mix.
I think that's really useful. And we use the word process a lot when we're talking on these podcasts about divorce, about separation, and when you're dealing with such a long and such an involved process, it's going to be holistic, and that's the best way to deal with it, because you can't isolate it from the rest of your life. there will be people who are listening to this who think, this sounds great. I'd love to do mediation. I want to deal with things swiftly and cheaply and keep things amicable. But my ex, they won't. They won't cooperate, they won't negotiate. That's an objection that I hear when I raise mediation. I raise mediation with most clients, unless it's very, very obviously not clear as an option. And that's the most common objection I get to it. How do you address that?
Yeah, no, and I'd be saying, look, we can. So our clients, your client is saying my ex is not going to cooperate. So I would always say, well, you keep an open mind about this. The point is that there'll be an invitation. It's their decision. It's their choice. But you never know. You've got everything to gain, nothing to lose by making that referral, because you and I know, well, all of us know on this platform that there is a pre-action protocol in place. So unless they're exempt before they go off to court, you've got to give an open mind about dispute resolution, right? And so I will always say, and I always say to my clients that you can only think for yourself, and you might have a reservation about your ex and what they think, but actually we're not in their head and we're not in their mind. And so really, let's at least put the invitation out there. What have you got to lose?
No, I think that's a really good way to frame it. And I think that what a lot of clients sometimes don't realize is you talk about mediation, talk about reaching an amicable settlement, and they think that's opposed to getting a judge to decide. But of course, we know that the vast majority of court-based or non-mediation-based systems will still settle by agreement, by negotiation. Just might be a longer process. So I think there's a lot that in terms of communicating that, and I think that's right. Why not give it a shot? And what's the worst that can happen? It doesn't work. Well, then you go to the thing that you would have gone to anyway. But presumably you've got lots of experience of people walking into or sitting on Zoom for an assessment meeting and coming from that view, and then actually reaching an effective settlement, a few sessions down the line.
Exactly, and that is the magic. So so long as if they're coming through your doors firstly, and it's interesting, I get a lot of clients who actually just come in directly through their own searches, and they've decided, because thankfully now mediation is gaining momentum, right? There is publicity out there. I mean, not as much as we'd like it to be. So that if they're coming in directly to me, that's a different scenario. But I was going to say, it's music to my ears, Matt, that you will say that you're always advocating mediation, and that's how it should be undertaken through lawyers, is to wholeheartedly advocate mediation as an option. Of course, if it was going to be a situation where it's never going to work because there is an exemption that you could tick box at your end, you're not going to come my way, and it's going because it's an emergency, the kids are going to be abducted. Of course, that's not a mediated case. You're going to go straight off to court. But if they have a warm introduction to the service, and yes, they might have doubts about their ex, and all I'd say is just keep them in check that we don't really know what the ex is going to do. This is an opportunity to at least keep an open mind and see where it goes. And ultimately, what I'll say is most mediators will then reach out and actually highlight the benefits to both parties. So in my case, I'm always highlighting, at the moment, we've got the £500 government voucher scheme, right? And how amazing is that? And so I'll straight away send invitation letters out to both of them. If it's a children matter, because of course it's only available, the £500 voucher for children issues, I will highlight that. And that's almost an incentive. So even if there's doubt on the other one who is, perhaps not willing to think about mediation, once they get into the assessment meetings, I'm then sort of honing in again on the benefits, to sort of saying you're going to remain in control. The magistrates don't know your children. Do you really want to give the power to them? So it's my job, where it is safe and suitable, to try and, I guess, persuade them to at least give this a go. So even just one session, especially with the voucher, they're not paying for anything else. They might have to pay for the separate assessment meetings, yes, but that's not a huge amount, bearing in mind the litigation costs. And even if it wasn't a children only and it was finances only where the voucher isn't available, the cost of a mediation session isn't a huge amount. It's worth, and so this is a way that I will be sort of trying to coach them into at least giving this a go, because I want them to stay in control and I want them to work things out. It is quicker, and emotionally it's less draining, isn't it? So the financial cost is one thing, but I always highlight the emotional cost and the ripple effect on your children and extended family members. The more amenable and amicable we can be, the healthier lives we lead post-separation divorce, which is great for our kids and it's great for extended family members and friends. So, and from my experience, that's been a huge incentive, because really that's within my model and my hourly rate, that's given them 2 hours free mediation. And where there are just child issues, you can sort things out fairly, within the 2 hours, sometimes where there's not too many topics to discuss. So I think it's a win-win, isn't it, really? And in terms of the legal work that needs to be undertaken, again, I'm a huge advocate, having, practiced family law, that absolutely when it comes to finances, they've got to take, legal advice. They always have that cushion. They always have that opportunity of coming back to you before they say, yes, we're going to agree to a proposal, just to make sure that, they're not selling themselves too short or giving too much, but they're coming back to you for the legal paperwork and making sure that the consent orders are then going to be in place. Obviously, for the children's side, it's parenting plans that we advocate. And again, back in the days as mediators, we were kind of doing that parenting plan for them at an additional cost. Now I'm advocating use a template. Kafkas has got a wonderful parenting plan template. So why pay more to me or anybody else? It's not rocket science. You just basically setting out what you both agreed and you're just following the template.
Yeah.
It's not means tested at all. The only criteria is there's got to be a child element to it. So if somebody's coming to me and it's purely finances, we can't apply for it. But if it's all issues or child only, absolutely. So long as they sign the consent forms, I then send off to the Family Mediation Council, and within a week or so, I'm getting confirmation. And so far, they've all been granted. So there's still money in the kitty. Clearly, the day I get a rejection means that the kitty's run dry, right? So
Yeah. I'm just wondering, just moving on slightly to the actual session itself, something that might be useful for people to hear is, and I'd be really interested to find out a bit about it, because I talk to clients about mediation, but I'm not a mediator, and I've never actually sat in the mediation because I've not been through mediation myself. So I know about it from speaking to really great mediators that I work with and refer to. We're really interested to know a little bit more about the actual role of the mediator within those sessions. So you describe it as being this neutral third party, but what level of involvement do you have? How do you manage these sessions?
yeah, so again, it's personality traits, right? So yeah, we are third party neutral, but I'll say I'm quite pragmatic within my mediations. I guess it's to do with my background, being in this sector for 30 odd years, and also the fact that I've been through my own separation, divorce, right? And not that you're then going to bring your story or your what you've been through into this mediation, but it helps that I know what it's like going, being in their shoes. But really, I'd say, my role is I don't just sit in the fence and just let them, bicker or spiral out of control. The role of the mediator is to lean in as and when you think that things are going out of control, or they're actually, sometimes that they're actually saying that this is what my lawyer said, or this is how I understand it to be. So if you think they're going off track and actually factually it's incorrect, you would then go in and you'd give them that pragmatic guidance and information. So always make it very clear. I can give you, legal information, but it's not legal advice, and it's always given overarching principles, in a neutral way. And so managing conflict, managing emotions. So the role of the mediator is to make sure, like I said, to always make sure that it is a safe space and it's not being used as a form of extending abuse. So you might have not tracked something, when you do your assessment meetings, you get into your mediation, actually it's, all out war because they just want to have a dig. And so again, you've got to step in and you've got to remind them that this isn't what mediation's about. Occasionally, I've had to actually say, I'm sorry, this is not, going to work because I can see it's toxic and it's counterproductive. So I guess we've got to be eyes, ears, and we've also got to be able to be able to listen to what both the parties are saying and then I guess summarize to them, because sometimes one party is seeing red. So one has said something and the other has misinterpreted or not actually heard them because they're already triggered by something. And quite often I'm going back and say, well, this is what I understood you said, correct me if I'm wrong. So I'm then trying to get them back on track because I know there's just been a misunderstanding, because you don't want it to escalate, right? So you really got to be their eyes and ears to be able to keep it on track, to keep it productive and moving in the right direction, I'd say. And also, obviously, making sure that they will, lean into you as and when they need to. So I always make this clear at the outset that you're not persuading me. You are actually having the conversations with each other. So what tends to happen sometimes is that they're thinking that I am judge, jury, and arbitrator, and they're trying to explain to me and trying to get me to, and then I have to remind them that these are your agenda items. You're explaining to one another what your views are and what the solutions are. You're not persuading me, but lean in when you need to ask me for guidance on anything, or I will step in when I need to. So yeah, it's getting the balance right. Ideally, they should be doing most of the talking, not the mediator. But you do have to lean in from time to time to make sure that they're on track and they're not misunderstanding or being misunderstood. Um, and giving them whatever tools and resources they need for the various issues they have. So quite often I'm like going on about separated parents information program, because you can do those and pay for those now on a private referral basis. That's a really huge positive, because back in the days you can only have those when you made a court application, but we've now got the opportunity to actually purchase those. And then the apps and tools that parents can communicate better with. So these are the things which they find really, I guess, useful, because they can then go off and read about them, do their homework, and perhaps work together. And as I said, the CAFCAS's website and the parenting plan is a gift to parents, as well as their booklet that they've prepared, which I'm sure that you will no doubt bring to your client's attention on for separated parents.
Yeah, absolutely. And while we're on the subject of resources, perhaps a good time to touch on your book, which sounds like a really fascinating resource for people about holistic divorce. So perhaps a good chance for you to plug that a little bit,
Plug my
Sushma, because I
book.
think
Yeah.
people will find it really useful.
Well, I hope so. So again, another labour of love. When I say another, the website was my first labour of love when I launched Holistic Family Mediation, and the book is called Holistic Divorce. Shit happens. It's how you deal with it that counts, and that's come about because that's a phrase that I'd use quite often, because shit does happen, and we all have a choice on how we're going to deal with it. And so this book is actually my knowledge and wisdom, on having represented God knows how many divorce clients in my 27 years as a divorce lawyer, and mediated so many cases, as well as my own separation divorce. So it's actually giving guidance, tools and resources to those that are facing divorce and family breakdown to take a breath, take stock, and firstly look at their emotional, psychological well-being and how it's impacting them, in that way, as number one. And so that's the holistic part. And so it's giving them tools and resources to be kinder, be compassionate to themselves and to the other party. And it actually takes them through, in each section you've got, it's a useful tool for co-parents, definitely, because it goes more into detail about the different ways of making the arrangements for the children. How should we tell the children? How do we tell our family members? All these things that you don't even think about unless you've been through it. These are questions that come up in your mind, and it's like, well, how do I tell my mum and dad? How do I tell my work colleagues? So it's actually giving guidance on how you'd be able to have these difficult conversations, as well as giving some guidance on the law that's applicable, because it needs to sort of set that out, but it's not too legalese. It's more soft topics, soft issues, and I'm hoping that anybody can pick it up. It's not one of these books that you read from page 1 to the end. No, you can just delve in and delve out, because each chapter and each section is set out very clearly. And so whatever has come to mind, in terms of their divorce and separation, emotionally, psychologically, or even legally, it should be there. I'm a great believer in yoga, meditation, breath work, the chakra system. So I kind of go off at a bit of a tangent, which may be too much for some people. But if you keep an open mind, like I said, ultimately, it's keeping an open mind and actually thinking about the bigger picture, always having in mind the vision for your future. So, when you're going through divorce and separation, you just feel like all is lost, and, you feel very vulnerable. Your lifetime's upside down, your children's lifetime's upside down, and people don't think they can get up from the floor. And I'm kind of giving them the confidence to say, you can and you will. And these are the tools and resources. If you just keep an open mind and implement, whatever resonates with you. Everything won't, but just the simplest thing, if you just start, consistently changing one thing in your life, it is a trickle effect. And for me, most importantly, I think I've put that out there, this tool and this resource and this service, because it's the impact that it has on our children. So we all know that conflict is the adverse childhood experience, right? It's not the parents separating and splitting. So again, it's giving that knowledge and wisdom and guidance to say, we all have this guilt, shame, and how's our kids going to feel? Well, if we then want to turn that around and actually take responsibility and deal with it in a dignified way, in a compassionate way, It's going to be benefiting us. It's going to benefit our kids because they're not going to be screwed up because they've seen mum and dad working together. They've worked through their stuff, and emotionally, psychologically, they've gone to a therapist, they've gone to a coach, and they can actually work together. So I guess the basis of this book is to say, let's flip the script on divorce. Does it have to be so bitter, toxic, and twisted? No, it doesn't. We all have a choice. Yeah, a lot happens and a lot of wrong may have happened, but that's the past. Leave that there, accept it. And if we can even be big hearted, forgive, because forgiveness is good for us because it sets us free to move forward. So it's not all legal. It's got all this knowledge and wisdom through my own journey in divorce. And I'm hoping that, it has a positive impact on, separating families, their children, and I guess future generations.
Right, it sounds like it's going to be a really great resource for anybody that's going through a separation. I mean, looking at sort of your experience with writing the book and your experience with being a family lawyer and a mediator and the holistic approach that you come from, if somebody that's listening at the moment is at the very early stages of separation or they're considering mediation, what would you say would be your sort of top 3 things that they should be considering or doing to try and have that more holistic kind of divorce going forward?
So well, number one is education is key, right? So if they're interested within, after listening to this talk, and because it might be new, people are probably thinking holistic. We thought holistic meant we're just looking at the family as a whole, not mind, body, spirit, and soul. So it's a case of going on. So my website's got a lot of information on there. You don't have to pay for it. Go in and do your own research and get the education in place, right? And then book a free discovery call. So like most mediation services will offer that these days. I mean, I do, and I know Stowe offers free options calls. So it's a similar thing. You've got to check out, which service resonates with you, because we all bring a different personality to the table and we all have got our own unique selling points. And maybe this isn't for them. And as I said to you, I know there'll be a huge number of people which actually this is over their head and they just want a normal, I say normal, a mediator who practices within the traditional way. They're not bringing this holistic approach to it. So that would be, the second thing that they need to do. But, thirdly, regardless, and I don't know whether this is the lawyer in me and my legal background, I still think when you're going through separation and divorce, you must take some form of legal advice. So again, I'm a big advocate of, you don't have to necessarily pay for it. There are lots of lawyers there, as Stowe do, offer free options calls. Just, be empowered, have that knowledge. You can't make a decision unless you're informed. Don't make decisions blind. That's why we're all about full and frank disclosure. It's with same thing in any of our life decisions. Before you actually decide one way or the other, do your research, do your homework. And it's not just one mediator or one lawyer. Pick 3 who resonates with you. Price, is this within your price bracket? It's all really important, isn't it? Ultimately, and having the confidence in whoever you decide to hire, whether it's your mediator or your lawyer. I think that trust and faith and confidence in the service that you're paying for is really important.
Yeah, I think we say that a lot, don't we, about choosing your team,
Yeah.
and that, we might not be the right person for everybody, but it is about doing, shopping around and making sure that you've got the people there that you can trust.
Yeah, absolutely.
Thank you, Sushma, for talking to us today. I think that's been really, really helpful, and I've certainly learned a lot. And it was really interesting to hear about in particular, the holistic element of the family mediation work that you do. So that's it for this episode of Stowe Talks. Thanks for listening. You can find out more about all the work that Sushma does at www.holisticfamilymediation.co.uk. If you would like more information on our podcasts, head over to stowetalks.co.uk and please rate, like, share and review this podcast where you can.